Everyone has an angel, a guardian who watches over us. We can't know what form they'll take. One day, old man. Next day, little girl. But don't let appearances fool you. They can be as fierce as any dragon. Yet they're not here to fight our battles, but to whisper from our heart, reminding that it's us. It's every one of us who holds the power over the worlds we create.
To be abused.
So, all of that kind of said, let me just go through. This is from Michael Benicia's website. Okay, so I'm just going to read through. There's two main kind of cases, or two main things that he's talking about. This was the one where his sister, who had a £1.85 million mortgage. Wow, right? So he's basically, this was on this was in July 2019. And it's just saying, it's now been confirmed that the Land Registry has altered the register to show that my sister is the owner of a family home, free and clear of the void mortgage which was cancelled earlier this year. This is highly significant because there was no attempt to create another illegal mortgage over the property by the Bank of Scotland, which means that His Honour Judge Barron's 2014 declaration that they are still owed 1.85 million is now held to be void and unenforceable by Land Registry. Okay, what he then goes on to say, and this is kind of the crux of his kind of argument and his process, right? This is what his lean-backed process is kind of all based on, right? The decision shows that in fact and at law, no mortgage, whether legal or equitable, can arise without a deed and a contract which comply with sections 1 and 2 of the Law of Property Act Miscellaneous Provisions 1989. He's actually typed that up wrong in his blog. Obviously didn't check it, did he? I can talk typos.
Yes,
you know what I mean? We'll let him on a typo.
You can type typos, you don't talk them very well.
But anyhow, right, so that's basically what he's going on about. So let me just recap with regards to the crux of his argument. What he's basically saying is that under the Law of Property Act Miscellaneous Provisions 1989, okay, if you have a deed, this is a mortgage deed, let's pretend that this is a mortgage deed. So if you execute a mortgage deed, all right, and the witnesses are not there at the date and time that you sign it to witness your signature, then it is void, right? The mortgage deed is void. Now, that's actually stated in the Law of Property Act, Miscellaneous Provisions 1989. It's got to be witnessed at the same time it's signed, otherwise it's invalid, right? Yeah. Now, if this document is invalid, and this is the mortgage deed, okay, then you can't have a proper mortgage.
Right, that makes sense. Yeah.
Okay? And if you can't have a proper mortgage, because this is the mortgage, so let me make it quite clear. A mortgage is, some companies will define it as just a mortgage deed. Other companies will define it as the mortgage deed plus the offer letter. And other companies will define it as the mortgage deed, the offer letter, and the standard mortgage conditions. Right. Okay, added together. Yeah. And then I take it one stage further, because it's common sense to do so. I add in all the documents executed under the power of attorney clause. Right. You add that all together, and that is the mortgage. And the mortgage is the security for the loan. Yeah. Okay. So let me just point this out, because it's going to become very, very relevant. You go to the bank because you want to buy a property, a house. We call it a house, right? The bricks and mortar. You want to buy bricks and mortar, something of substance. So you go to the bank for a loan. We'll forget the fact that they don't make loans. In their game, they're making loans, right? So you go to the bank for this big loan. So what does the bank say? I mean, bearing in mind they give you aggravation if you apply for £1,000 or 1,500 quid. What are they going to do when you're applying for 250,000 or 700,000 or whatever it is? They're going to say that they want some security.
Yes, he wants an equity.
So they agree to give you the loan as long as, or subject to, it being secured by way of a mortgage. The mortgage is the paperwork. Yeah. So you have two elements to the deal that you're getting into with the bank. You have the loan and you have the mortgage, because the loan is granted subject to a mortgage being granted over property, or subject to security being granted by way of a mortgage, right? Whichever way you want to word it. Yeah. So what Michael's saying is that if the paperwork is incorrect, all right, this is what's in the Act. It's got it in the Act. So Michael's restating the Act. If the paperwork is incorrect, you can't have a valid mortgage. Right. Well, that's kind of common sense, right? It's obvious, right? Yeah. And if you haven't got a proper mortgage, then you can't have a legal mortgage, whichever way you want to look at it, either arises from or derives from the mortgage. Right. And then what Michael is kind of implying in his write-ups, and he's got, as I say, this one about his sister, and then he's got another one, which I'll read out shortly, about his father. But what he's basically saying is he then goes on, takes another step, or doesn't actually explain this properly, which I'm gonna tear this apart for you.
Explain it in detail.
Yeah, I will. Yeah. But he then kind of makes a leap, or implies or infers that then kind of negates the loan bit, right? So that if the mortgage is invalid, which means the legal charge can't be there, the legal mortgage can't be valid, then that makes it all unenforceable. No, right? I hope that I'm proven wrong. Yeah. Right? And if I am proven wrong, fine, brilliant. It's great to have these kind of scrutinizing debates, as it were. Yeah. All right. You have to you have to put a process up for scrutiny,
Yep.
and because it has to hold water, right, as the old saying would go. And so if it can't get past your peers because of some argument and someone saying, well, what about this, what about that, that don't make sense. Well, if it can't get past your peers, how's it going to get past the judiciary, right?
Exactly. Yeah.
So so I hope I'm wrong, right? I have a sneaking suspicion that I'm right, but there you go. So let me just read out this bit about the post about his dad. So as I say, this post about his sister was the I think it was the 19th of July. It was July 2019. I don't know exactly what. Oh, it was the 2nd of July 2019. There you go. So that's on the Bernician, and then you've got this one, which was actually a repeat of a post. He said he's repeated this post. Actually, I can't see when this was the repeat of the post. But anyhow, it looks like it was from July 2014. But anyhow, I'm just going to read some snippets, right? So this is about his father's thing. So His Honour Judge Behrens, albeit somewhat reluctantly, handed a summary judgment to the trustees. So this is Michael's side, who are defending a despicable claim by the Bank of Scotland, which seeks to make my parents bankrupt over the shortfall in the allegedly outstanding debt, following the fire sale of 9 properties at an average of 27% of their market value by the LPA pirates, he's called them. So this is Michael, right? Man of the people, whose family have got, actually it was 12 properties he said they had, and 9 mortgages. But in this bit, he's talking about 9 properties have been sold off, right? So landlord, okay. And so obviously there'd been shortfalls. They'd sold it off cheap. We know they do that.
Yeah.
That's left debt. That's left shortfalls on the mortgage balances, and they were following up, chasing up his dad or his parents to try and make them bankrupt, right? So Michael was defending this, and he's using these arguments to try to defend this, right? So where are we? The bank's claim was entirely reliant upon a purported contract for mortgages, right? In the future being valid. The document in question, which takes the form of a facility offer and acceptance letter, so a facility letter, offer and acceptance he's got in square brackets, was never signed by a representative of the bank, rendering it void ab initio under Section 2 of the Law of Property Miscellaneous Provisions Act 1989, right? So, okay, let's just touch on that point. The loan element, okay, is generally agreed by way of an offer letter. Yeah. And they generally send out, for first mortgage business, they would send out, and I say first mortgage business, this is your house purchase plan or a remortgage, they would generally send out 2 offer letters. Yeah. Okay. And I'll be honest with you, in most cases, as someone that's worked in the industry, they are signed by the bank. Yeah. Right? And then you have to sign it to accept it, and you keep one copy and you send a copy back. Offer and acceptance is your contract. Yeah. That's for the payments. Okay. Now he's saying that the bank didn't sign their one. So fair enough. I mean, in Michael's cases, it looks like the bank has really goofed up on this product, right? Or on this facility that they set up. So he's saying that they didn't sign theirs, which made that one invalid, right? According to the Act, Section 2 of the Act. Then he goes on, Judge Behrens has nevertheless conceded that one of the purported mortgages is void on the basis that it was not properly witnessed in breach of Section 1, subsection 3 of the 1989 Act, right? Which is significant for a number of reasons. Then he's got here, the trustees have been arguing that 9 mortgages over 12 properties are void and unenforceable throughout both the original proceedings, which went before His Honour Judge Wharton in the High Court in Newcastle on the 22nd of October 2010. Right? So this has been going on for a long time, right? So it's 9 mortgages over 12 properties. And by the sounds of it, okay, when you get down to the nitty-gritty as to why the deed hadn't been witnessed, it's actually stating here that there was apparently no space on the form for witnesses, right, which I find absolutely amazing that Bank of Scotland have made that kind of boo-boo. So it looks like with their paperwork, whatever's happened, Bank of Scotland have made a complete botch up. Yeah. And I'm wondering, I don't know for sure, maybe someone out there knows the answer, maybe Michael can clarify, but I don't know whether the 9 mortgages were all with Bank of Scotland. I'm assuming they were, by the way that this is worded, when he's saying Bank of Scotland, were pursuing the fire sale of 9 properties. So certainly they've got the mortgage over 9 properties, it would appear, right? And I guess the other 3 properties came into it because they're trying to rope those into the bankruptcy, no doubt. So it looks like all the mortgages, correct me if I'm wrong, Michael, but it looks like all the mortgages were with Bank of Scotland. And if Bank of Scotland were operating under that kind of standard where they're issuing a mortgage deed with no witness space, and they're sending out offer letters to be, or contracts, and they're not going to sign their part of it, well then you're in for trouble, aren't you?
Yeah.
Right? So no wonder there's issues with these documents, right? So okay, on the one hand, it looks like the bank tried to, with the assistance of the courts, tried to railroad everything through early doors or first time round without the proper paperwork. Yeah. And I would imagine they've never really been challenged on this in the past. So hats off to Michael for sticking with it, okay, demonstrating tenacity, and of course probably one of a small minority of people that would be tenacious enough to stick with it. Yeah. Okay. Most people buckle, bend over, fold, whatever, right? Most people give up. Yeah, at very early doors, right? So what Michael's then done is, as a result of this, as I say, he's then, when he's finally kind of got the decisions that he needs, so in this case with his father, it looks like there were a number of points they were arguing on, and one of the points was conceded, which meant that, again, he'd had a kind of result which acknowledged that, if the deed has not been witnessed properly, then it's invalid. So they've now got some case law to acknowledge what's in the bloody Act of Parliament anyway, right? So what he's then done, as we know, is he's then produced the Great British Mortgage Swindle, okay, and he's got these class or group actions which are taking place, and he's basically saying that, well, look, what we're going to do is we're going to challenge, there's not a valid mortgage in the country. No. I mean, again, but let's throw into that they're not dated, right, on the day of execution. So in other words, if I speak properly, in other words, in the majority of cases, I would say in 99.999999% of cases, right, the deeds are left undated when they're signed by the customer. Yeah.
In fact, you're told to quite often.
Yeah, you're told to leave. In fact, they do. They actually say on there, leave it blank. And then what happens is the member of staff on the day of completion will actually date the mortgage deed. Now that itself should invalidate the deed. Yeah. It's not kind of clearly spelled out as much as I would like it to be clearly spelled out in the Act, but that's the way that it should be. That's the way that it all should run. Now, obviously, it's quite convenient for Michael, and a bit of a result for Michael, the fact that there were no spaces for witnesses to sign, because that is clearly spelled out in the Act, right? The Law of Property Act miscellaneous provisions. And so, of course, he was able to then utilise that as a more blatant violation in order to get the mortgage deemed to be invalid. And if the mortgage is invalid, you then can't have a legal mortgage arising from it. So you've got the two elements of the deal. You've got the offer and the acceptance. This is for the loan, and then the loan is protected or secured by way of a mortgage. So the mortgage paperwork, right, is invalid. No. Okay, so there's no mortgage. So now what have you got? You've not got a secured loan. No. You've now got an unsecured loan. Right. So as a debt collector, what would but as I'm researching this, I'm thinking to myself, well, okay, if there's no security, what would I do as a debt collector? Answers on the comments. What would you do as a debt collector if you've suddenly lost your security? What would you do? What could you do? What are your options?
You can always suck your thumb and hope for the best.
Yeah, you could do. Yeah. You could hope that the customers who haven't paid, even when it was a secured loan, are suddenly going to, God, I'm having a real problem speaking today, are suddenly going to start paying now that it's an unsecured loan. You could hope for that. Yeah. But I would say that you're, Bob hope, no hope. And if you live in Essex, Stamfordly hope, right? As I often used to say. That's a locale in Essex, Stamfordly hope. Bob hope, no hope, Stamfordly hope.
Okay. Sinead says, go for a summary summons for the money.
You'd go after the money. You'd go after the money.
Loris is probably quite close to the truth as well. She says trick buyer into giving a new security.
Yes, you could do. Actually, you could say, yes, there's a problem with the paperwork. We need you to sign a new one. Thank you very much.
And Stephen also is on the same thing. He said pretend there's still a secured loan and take the property.
Well, actually, you've pretty much got that one. Default breaches and other matters. Section 22.2. We may give you notice requiring you to pay us the money you owe us immediately. Then we go down here and we get to L. So after K. If any of the following are set aside or found to be ineffective or only partly effective. The first one that's on there is the mortgage deed.
Right.
Right. So you don't even have to look at anything else. If the mortgage deed is ineffective or only partly effective, they can call in the entire loan. Stands to reason, common sense. Why? Well, because the loan, as you agreed at the beginning when you signed the offer letter, was only granted on the basis or subject to security being granted by way of a mortgage, right? And the mortgage being granted over the property. So if there's no mortgage in place, the loan, the requirements for the loan have not been fulfilled. So they call the loan in.